This case has the potential to end the internet as we know it. The internet flourishes on user-generated content. It's the backbone of the internet. And if you write or say something that is illegal, you can be held liable for what you said. But usually the websites that host your content are not liable. And when you hear about Section 230, this is usually what we're talking about. But if websites were also liable for what users say, then websites would either shut down almost everything or police things so tightly that there would be basically nothing even remotely objectionable. Because if there's one thing that websites hate, it's being on the hook for billions and billions of dollars of potential liability and attorney's fees. And this isn't just some potential hypothetical. In the past, when laws made websites liable for user content, they just shut down the content and never came back. And one case before the Supreme Court this term seeks to do exactly that, but for all of the internet. No joke, this has the potential to end the internet as we know it today. So how did we get here?
How did I get here?
Well, it started with a tragedy. Noemi Gonzalez was a design major at California State University, Long Beach, who was spending a semester studying in Paris. On the evening of November 15th, 2015, she was dining with friends at a cafe on the Champs-Élysées when an ISIS terrorist with a gun opened fire. Gonzalez was killed along with 130 other people in coordinated attacks at 6 locations across the city. ISIS claimed responsibility for the attacks, and eventually 20 men were convicted of crimes related to the massacre. The lone surviving gunman was sentenced to life without parole. So, was justice served? Well, the Gonzalez family contends that it was not because there was another perpetrator still at large: YouTube. The family sued Google, which owns YouTube, alleging that YouTube's algorithms amplify violent videos and hateful content despite the company's efforts to ban violent accounts and limit their reach. The Gonzalez family says that YouTube's recommendations expose people to hateful content, radicalize viewers, and encourage them to make terrorist attacks of their own. Google argued that because ISIS, not YouTube, made and uploaded those videos, YouTube was not the provider or developer of those videos, and therefore it was immune from liability under 47 U.S.C. Section 230, otherwise known as Section 230 of the Communications Decency Act. Section 230 of the CDA immunizes internet services for the content that its users upload and often allows websites to remove content without taking on liability. But the Gonzalez plaintiffs contend that YouTube's recommendations should not be covered by Section 230 because the company is acting like a content creator rather than a publisher. The Ninth Circuit Court of Appeals held that the Gonzalez claims fell within Section 230 and Google was immune from suit. The Gonzalez parties appealed, and the Supreme Court granted cert to answer the question of whether Section 230 immunizes an interactive computer service from liability for recommending other party content. Now, in support of their claims, plaintiffs allege that, quote, 2 of the 12 ISIS terrorists who carried out the attacks used online social media platforms to post links to ISIS recruitment YouTube videos and, quote, jihadi YouTube videos. One of the men who fired at Gonzalez had appeared in an ISIS recruiting video in 2014. Now, the plaintiffs argue that the defendants violated the Anti-Terrorism Act, the ATA, by allowing ISIS to post videos on YouTube. Under Section 2333 of the ATA, as amended by the Justice Against Sponsors of Terrorism Act, Americans who are injured by, quote, an act of international terrorism that is committed, planned, or authorized by a terrorist organization may sue any person who, quote, aids and abets by knowingly providing substantial assistance or who conspires with a person who committed such an act of international terrorism and recover treble damages. So the legal question in the lower courts was whether a social media platform that was not used to commit a specific, quote, act of international terrorism may still be liable for aiding and abetting under Section 2333. The plaintiffs say that the answer is yes, that Google aided and abetted an act of international terrorism, conspired with the perpetrator of an act of international terrorism, and provided material support to ISIS by allowing ISIS to use YouTube. And of course, the defendants say no, the plaintiffs' claims are barred by Section 230 of the Communications Decency Act, which often immunizes interactive computer services, aka websites, even when they make targeted recommendations. The trial court and the Ninth Circuit Court of Appeals sided with Google, ruling that the claims fell within Section 230, Section C, because ISIS, not YouTube, created or developed the relevant content. The court said that YouTube, quote, selects the particular content provided to a user based on that user's inputs. The display of recommended content results from algorithms that are merely, quote, tools meant to facilitate the communication and content of others, and not content in and of themselves. As the lower courts noted, the recommendations are based on the user's preferences, not YouTube's. The plaintiffs argue that Section 230C does not apply to, quote, activities that promote or recommend content. So let's dig deeper into what all of this means. First of all, the plaintiffs are not simply arguing that platforms are liable because terrorists have used their services. They argue that the powerful algorithms that recommend content are not covered by the CDA because the recommendations are content in and of themselves. And as the Ninth Circuit said, the complaint alleges Google uses computer algorithms to match and suggest content to users based upon their viewing history. The Gonzalez plaintiffs allege that in this way, Google has recommended ISIS videos to users and enabled users to locate other videos and accounts related to ISIS, and that by doing so, Google assists ISIS in spreading its message. So the plaintiffs claim that YouTube facilitates communications between ISIS and people who watch their videos, thereby aiding ISIS in recruiting new members. The plaintiffs acknowledge that YouTube removed ISIS videos and suspended or blocked ISIS users at various times. However, the plaintiffs claim that YouTube should have been able to stop ISIS from re-establishing the accounts using new identities. And the plaintiffs allege that Google left some of the ISIS videos up because they did not contain content violating the site's policies. At other times, Google removed the offending content, but did not suspend or ban the accounts. Now, we've talked about Section 230 of the CDA many times on this channel. Section 230 was created back in 1996 at the dawn of the internet. It has two key provisions. Section 230C1 says, quote, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. This sentence is often called the 26 words that created the internet. This section stipulates that providing access to third-party content does not make an online provider the publisher or speaker of that content. Now, the second major part of the law is Section 230C2, the so-called Good Samaritan provision, which states, quote, no provider or user of an interactive computer service shall be held liable on account of any action voluntarily taken in good faith to restrict access to or availability of material that the provider or user considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected. So this provision gives online platforms broad immunity from liability if they moderate content in good faith. This provision was meant to allow websites to police itself without incurring new liability because it was an issue of knowledge. A website might not know what speech was hosted on that particular website, in which case they wouldn't be liable for it. But if they knew that illegal speech or defamatory speech or some other kind of speech was hosted there and then took steps to remove it from the website itself, then they actively had knowledge of that particular speech and thus might become liable for hosting it in the future. So websites found themselves on the horns of a dilemma until Section 230 of the CDA was passed to allow them to engage in good faith moderation. Because there was generally a knowledge requirement to be liable for things that were hosted on your website. If you had no knowledge of what kind of speech was on your website or platform, then you generally weren't liable for it. But the argument went that if you started to moderate your website, then that was evidence that you knew what was on there, and therefore you became liable for all the stuff that you were trying to remove from your website. And this applied to spam, to pornography, to pirated media, to defamation, you name it. So the CDA was enacted in 1996 when the internet was still in its infancy. At the time, companies like America Online, CompuServe, and Prodigy were the portals that allowed people to access the internet. People could share files, exchange messages, and chat with each other in real time. But that posed a dilemma. Who would be liable if a user posted something defamatory or shared something else that was illegal? Would liability go beyond the person that was responsible for the post? Or would the internet companies who hosted the content also be on the hook? And that brings us to the distinction between content publishers, distributors, and platforms, which is often completely misunderstood. In the pre-internet age, publishers, distributors, and platforms were treated differently under the law. Publishers were newspapers, magazines, and broadcast stations. They were generally liable for republishing material from third parties since they solicited the things that they published and they could vet those materials. Distributors were businesses like bookstores, newsstands, and libraries, which distributed material that was printed by others. And distributors were not required to assess every book that they sold. For example, in the 1950s, the Supreme Court overturned a Los Angeles ordinance that said, if you have obscene material in your bookstore, you can be held criminally responsible. And in that case, a bookstore owner was convicted of violating the ordinance by selling a novel called Sweeter Than Life, which tells the story of a, quote, ruthless lesbian businesswoman. The Supreme Court said that the bookstore couldn't be responsible for reviewing every single thing in the book or magazine that it sells. And distributors only had liability if someone notified them that something they carried was illegal. That's sort of the origin of the knowledge requirement. And platforms were common carriers like phone companies and television broadcasters. Platforms weren't liable for third-party content that they carried. So, for example, let's say AT&T found out that someone's answering machine had a libelous outgoing message. Was AT&T required to act by canceling the owner's telephone service? Well, the court said no, AT&T couldn't be sued for libel simply because the owner used its service to say something libelous. And similarly, a broadcaster wasn't liable for running a political candidate that falsely accused someone of being a communist. But then the internet came around, and the internet era posed a new challenge for this case law. Two of the first internet service providers, CompuServe and Prodigy, were sued for hosting forums where users posted defamatory content. Now, Prodigy billed itself as a family-friendly version of the internet.
Did you get a computer recently? Well, congratulations. You can now join hundreds of thousands who've discovered Prodigy.
It moderated comments, removing things it thought were bad. Now, CompuServe didn't moderate anything.
CompuServe combines the power of your computer with the convenience of your telephone.
And both of those companies were sued for defamatory statements that their users posted to the service. Now, the case against CompuServe was dismissed because the court considered it a distributor of content rather than a publisher. CompuServe could only be held liable for defamation if it knew or had reason to know of the defamatory nature of the content. And since they didn't do anything to moderate their forums, the company couldn't possibly know, or at least argued it couldn't possibly know, about what the denizens of Rumorville were posting about each other. But Prodigy was found liable for failing to moderate enough. Someone went on a forum and claimed that Jordan Belfort's investment firm, Stratton Oakmont, committed fraud in connection with a stock IPO. The firm sued Prodigy and the anonymous poster for defamation, and a court held that Prodigy was liable as the publisher of the content created by its users, since it exercised editorial control over the messages on its bulletin board. Now, if the names Jordan Belfort and Stratton Oakmont ring a bell, that's because they were literally scamming people out of millions of dollars and have gone down as some of the biggest fraudsters in all of Wall Street history. The movie The Wolf of Wall Street is based on the fraud that they were perpetrating with respect to the IPOs. And it's one of the biggest ironies in all of First Amendment law that they won this lawsuit against the people that were hosting presumably accurate information about how they were scamming people out of money. That's part of the problem when websites are liable for user content, is that people can file lawsuits to stifle speech. That's what a slap lawsuit is all about. And because lawsuits are incredibly expensive, sometimes even if you scammed people out of money, as long as you file a lawsuit, you can stifle that kind of speech. But I digress. As a result of these cases, internet service providers basically either decided to not moderate at all and leave absolutely everything up, or basically moderate everything and not allow anything to go up. And basically no one was happy with this state of affairs, so Congress enacted the Communications Decency Act. And then, as now, lawmakers claimed to be especially worried about things like harassment and obscene material. So they gave online providers immunity from lawsuits if they moderated content. And again, the irony here is that this legislation came from the sort of family values type politicians, the people who always want to think about the children.
Oh, won't somebody please think of the children?
They wanted to allow websites to remove violent and sexual conduct so that the internet could be even cleaner. The same politicians who wanted and got the little parental advisory explicit content warnings put on rap albums. But I digress again. Section 230 was intended as a way for internet companies to create and enforce basic standards to run their websites. And when the CompuServe and Prodigy cases were decided, the courts only considered whether the ISPs were publishers or distributors. But an internet service like a website didn't fit neatly into those categories. A traditional publisher has total control over whether to publish content. A distributor can control what it buys, but it wouldn't have been practical for a human to fully screen every item. Modern social media companies host more material than any library or bookstore on earth, which makes screening all of that info daunting, if not impossible. And without Section 230, social media companies would be subject to strict liability for every message and post made on their services. So Congress chose to give those platforms and websites immunity as an incentive to get them to remove offending speech. Congress also chose not to dictate to those companies which speech they had to remove. So that brings us back to the original question in this case. How should courts read Section 230? The lower courts follow the test set forth in the Ninth Circuit case called Barnes versus Yahoo, and the Barnes test hews close to the text of Section 230. The law specifies that only 1, no interactive computer service, shall be 2, treated as a publisher or speaker, of 3, content provided by another information content provider, aka users. Now, the plaintiffs argue their claims do not treat Google as a publisher, but instead assert a simple duty not to support terrorists. They said that the ATA prohibits Walmart from supplying fertilizer, knives, or other material to ISIS, and in the same way, the ATA bars Google from giving ISIS a platform to communicate. The Ninth Circuit found this analogy specious. The idea of a duty not to support terrorists, quote, overlooks that publication itself is the form of support Google allegedly provided to ISIS, and publication of third-party content is what Section 230 gives to internet services. According to lower courts, publishing encompasses, quote, any activity that can be boiled down to deciding whether to exclude material that third parties seek to post online. Google says that the CDA uses the words publisher or speaker in an ordinary sense. Quote, based on an ordinary meaning, a publisher or speaker is one that publishes or speaks. Google contends that when YouTube's algorithms make recommendations, this activity is protected by Section 230. Quote, Congress underscored that publishing for purposes of Section 230 includes sorting content via algorithms by defining interactive computer service to include tools that pick, choose, filter, search, subset, organize, or reorganize content. Congress intended to provide protection for these functions, not for simply hosting third-party content. And the plaintiffs disagree. Their interpretation of the Section 230C defense is that it requires a narrower interpretation of the word publisher. The Ninth Circuit previously held that Section 230C1 uses publisher in its everyday sense, and the Second Circuit agreed. But the plaintiffs contend that the word publisher is used in Section 230C1 with a narrower and distinct meaning, which that term has in defamation law. Basically, the plaintiffs are claiming that any time YouTube recommends another video, it therefore becomes the speaker of that video, as if YouTube had produced that video itself. Now, defendants say that this interpretation doesn't make sense. Quote, watch the World Series of Poker on YouTube, and YouTube's algorithms might display Texas Hold'em tutorials. That does not mean that YouTube endorses gambling any more than spellcheck endorses a suggested substitute word. Westlaw endorses higher listed cases, or a chat room endorses posts organized by topic. As the Ninth Circuit noted, YouTube applies the same algorithms to all content. And it's here that I think people often misunderstand the nature of the internet and the nature of social media. With the case of YouTube, people upload millions of videos a day. If there wasn't an algorithm to sort through this deluge of videos, the only way to sort through them would be a fire hose of viewing every video chronologically, which nobody wants. It would be that or doing a pointed search to try and find content, but then you'd never be exposed to content that you actually do want to watch but didn't know that you wanted to seek it out. And the plaintiffs have tried to differentiate between search results and other algorithmically generated results, but there's really no principled way to distinguish between results that are sorted when you actively search for something versus results that are presented to you because of a recommendation algorithm. And people love to hate algorithms, myself included. But the truth is, if there weren't algorithms to help us sort through all of the content on social media platforms, it would be impossible to wade through it. And then additionally, there's the issue of the material support related for a claim under the Anti-Terrorism Act. Now, the Department of Justice's brief in support of the plaintiffs argues that algorithmic recommendations convey the website's own implicit message that users will find the information relevant, and that makes the website liable because it's acting just like ISIS itself. Now, plaintiffs didn't claim this in their original complaint. Instead, they focused on how YouTube's recommendations amplified the ISIS speech, making it more visible to more users. But the US government urged the Supreme Court to adopt a narrow reading of Section 230 that would permit a finding that Google materially contributed to the content by matching it to user preferences. Again, basically, the Department of Justice, as well as the plaintiffs, are arguing for a standard that if any website promotes content, uses an algorithm, or recommends content to users, that website then becomes liable for all of the speech contained within that recommendation. What happens when websites are liable? Well, remember I mentioned that this has actually happened before? Well, it has. In 2018, then President Trump signed into law 2 bills making it easier to fight sex trafficking online. That was the Fight Online Sex Trafficking Act and the Stop Enabling Sex Traffickers Act, otherwise known as FOSTA and SESTA. And those 2 laws created an exception to Section 230's safe harbor rule by stating that websites could be held legally responsible if third parties posted ads for prostitution on their platforms. The law penalizes websites which, quote, promote or facilitate prostitution. And while this includes sites that promote illegal sex work, it also allows the police to investigate any site that is knowingly assisting, facilitating, or supporting sex trafficking. This language can be read to include sites with content that is legal, such as escort services, personal ads, and pornography. Now, critics of FOSTA and SESTA warned that the new laws were too broad and they would end up killing internet content that has nothing to do with sex trafficking. And they turned out to be correct. If a third party posts content that is covered by FOSTA or SESTA, and the website fails to prevent that content from being posted, that website can be sued. And that was simply too much legal risk for several websites.
You should have gone for the head.
Craigslist shut down its entire personal section. Tumblr banned all adult content, and Reddit removed several subreddits, and other websites just simply shut down entirely. So you might ask, did any of this assist with the prosecution of sex trafficking? Well, in 2021, the US Government Accountability Office released a report on the first 3 years of FOSTA and SESTA, finding that, quote, over 3 years, the Department of Justice filed just one case under its rules against promoting or recklessly disregarding sex trafficking. So ironically, this provided essentially the perfect natural experiment to find out what happens when websites are liable for the speech content of its users. One of two things will happen. Either the website shuts down that section or shuts down the entire department, or the website employs an army of moderators to remove anything even remotely offensive. You basically either live in a world where a website allows everything, scams, spam, pornography, ultra-violence, just everything that you can possibly imagine and you probably don't want to see in your everyday life. Or you live in a world where they employ extremely expensive moderators who prevent anything that might possibly be offensive. And that, of course, assumes that a website can even afford to employ those moderators. So there are those who want to see Section 230 modified or scrapped altogether and have argued that these online services are acting like content developers. Now, oral argument in front of the Supreme Court is next week, and I'm putting my money where my mouth is on this one. I filed a brief in the Supreme Court along with Dr. Mike, Mythical Entertainment, Chubby Emu, Tim Schmoyer, and the Authors Alliance, and a bunch of other creators. We filed an amicus brief explaining the potential dire consequences of a really bad ruling on this, so we'll see how it goes. But in the meantime, I'll probably just be stress eating at the end of the internet. Unless I use today's sponsor, Factor 75. Because Factor makes meeting your nutrition goals easier than ever by delivering fresh, never frozen, dietitian-approved meals right to your doorstep. And the meals are completely ready to eat. Their team of gourmet chefs creates each meal using ingredients with integrity to help you feel your best all day long. And I can tell you from experience, they really are extremely delicious. Factor supports wholesome eating made simple. Their menus are updated weekly with 34 different options. Choose your favorite meals or let Factor craft the order based on your taste preferences and meal history. Factor takes the guesswork out of grocery shopping and meal prep, saving you time and energy for other things. Their no-hassle prepared foods make sure you always have something nutritious on hand when you don't have time to think about making a meal. And sometimes I just want a good, healthy meal without having to cook, or obviously shop for the ingredients. And Factor's meals arrive pre-prepared and ready to eat in just 2 minutes. And I can always scale up my meals if I need the extra energy after a long day of lawyering. So give Factor a try by heading to factor75.com and use the code LegalEagle50 to get 50% off your first Factor box. Or just click on the link that's on screen right now or down in the description and use the code LegalEagle50 to get 50% off your first Factor box. And clicking on that link really helps out this channel. And after that, click on this box over here for more Legal Eagle, or I'll see you in court. Geico ordered to pay Missouri woman $5.2 million after she contracted STD in car. Geico must pay $5.2 million to woman who got HPV from sex in man's insured car, court rules. Well, I'm sorry to tell you that the headlines are wrong. But the truth is even more interesting because it involves nuances and esoteric details of insurance law. Now, you may have heard that Geico is on the hook for $5 million because a woman contracted HPV after she had sex with a man in his 2014 Hyundai Genesis that was insured by Geico. And it is true that a thing happened, that a lawsuit was filed between the former couple. The man knew he apparently had throat cancer that was caused by HPV, but did not tell the woman that he had it. She took him to an arbitration and was awarded more than $5 million. As lawyer Ellie Mistal put it, that was probably an expensive 15 minutes for Geico. Now, it occurs to me that I probably should have put a warning on this episode. If there are any kids watching, sex is when two people love each other and then wrestle in the back of a car. In this case, a 2014 Hyundai Genesis. And when those two people no longer love each other, they will sue each other for what happened in that car. Now, how does that implicate Geico, you might ask? Well, the man's car was insured by Geico. The encounter happened in 2017, and the woman filed an insurance claim, which Geico denied. Geico told the woman its auto insurance coverage didn't apply because the damages claimed did not arise out of the normal use of the vehicle, which I think we can all agree probably makes sense. And now, to understand this whole case, we have to take our first diversion into the nuances of insurance law. Because generally speaking, when you get an insurance policy, it provides insurance over, let's say an accident happening, an occurrence of some kind. But in addition, you'll often get what's called a duty to defend. In other words, if you are sued over something that might be covered by the policy, then the insurance company has to provide lawyers, or at least the funds for lawyers, to defend that case.
Send lawyers, guns, and money.
Now, when an insurance company refuses to defend its policyholder, it's considered basically the same as denying coverage outright, saying that the policy doesn't cover the accident that happened. So an insurance company that wrongfully refuses to defend its insured can be liable for the cost of the defense and any damages that arise from the breach of their duty to defend. Now, how do you know if a policy is going to apply to an accident or whether the insurance company has a duty to defend you? Well, you look to the four corners of the complaint in the lawsuit and you compare that to the policy itself. This is called the four corners rule, or sometimes the eight corners. You're comparing what's contained inside the lawsuit complaint to what's contained inside the policy. And if it's possible, if it's a remote possibility that this claim could be covered by the insurance policy, then the insurance company has to provide you with a defense. Now, if the allegations are untrue, then the insurance company won't have to pay a judgment because, well, they'll win. But you can't know that until the trial is over, which is why the insured needs someone to pay for their defense. And that's why there's often a duty to defend under certain policies. And that's why sometimes the defense costs are the whole ballgame. If the insurance company denies the defense, then the insured might be in a world of trouble. They have to defend against a lawsuit all on their own, and lawyers are expensive. Now, an old partner of mine used to say that the only thing an insurance policy gets you is the right to sue an insurance company. In other words, if they deny your defense or deny coverage, then you might have to sue the insurance company if you lose the initial case going forward. But that's why some plaintiffs' attorneys will actually specifically try to cast their allegations in a way that will invoke insurance coverage so that they make sure the insurance company is part of the litigation. They'll either add another claim or they will craft the story of what happened in a way that might fall under coverage of the insurance company, because the insurance companies tend to be the ones that have the big pockets. So now we come back to this particular case. In February of 2021, the woman sent Geico a copy of a lawsuit that she was about to file against the insured, the guy that she had sex with in the car. She offered to settle the claim for $1 million. Geico ignored the notice. Basically, Geico decided that the claim wasn't covered and refused to defend. Basically, Geico said, having sex in a car that we insure is not covered under the policy, so we're not going to provide coverage and we're not going to provide a defense to the guy whose car it was. And for the record, these people only use their initials in the lawsuit, which was probably an incredibly smart decision so that they don't go down in history for something that may or may not have happened in this particular suit. And for the record, MO is the injured party. She's the one that contracted HPV. MB is the man with the car who gave her HPV. So now we're in 2021. MB is going to defend this lawsuit on his own dime because Geico has refused to provide a defense. So Geico basically takes itself out of the picture. At which point the insured, MB, the guy with the car and the STI, enter into an arbitration agreement with MO in March of 2021. And they agree to settle their dispute through arbitration. Now, Missouri's insurance laws have some procedural quirks, and the relevant statute is section 537.065. That statute allows a claimant, like MO, to enter into a contract with the tortfeasor, here MB, the guy with the HPV, to settle their dispute in private arbitration, which would be much, much cheaper and much, much quicker than going to trial in state court. Now, you're allowed to enter into one of these agreements when the insurance company has refused to defend the insured or agrees to a defense under a reservation of rights, which I won't go into. Now, the parties enter arbitration with an agreement that the maximum payout that the arbitrator can give is whatever the insurance policy limits are, and generally that the plaintiff won't go after the defendant, the tortfeasor, and will just take the judgment and use it against the insurance company, which, as discussed, depends on whether the claim is covered or not. Effectively, the plaintiff is gambling that the claim is or should have been covered. And if they win in arbitration, they're going to take that award and say, you insurance company, you should have covered your insured, and therefore you can just pay me everything that was owed because we made this side agreement. So in other words, once you get an award in arbitration, either the insured sues the insurance company and turns that money over to the claimant, or the claimant standing in the shoes of the insured sues the insurance company saying that they wrongfully denied coverage or defense costs. That's called subrogation. Now, obviously, insurance companies hated all of this, and that's why this section has been amended twice, once in 2017 and once in 2021. And this is effectively exactly what happened here. They went to arbitration without Geico, because Geico said they didn't want to participate, they didn't think it was covered, and the claimant got an award of $5.2 million. And the arbitrator found, and yes, this is the actual language that the arbitrator had to find because law is interesting. The arbitrator found, quote, there was sexual activity in insured's automobile in November, December of 2017, which occurred in Jackson County, Missouri. 2, the sexual activity in insured's vehicle directly caused or directly contributed to MO to be infected with HPV. 3, insured knew or had been told his throat cancer was diagnosed as HPV positive. 4, insured should have disclosed his diagnosis to MO prior to their sexual activity that occurred, and he did not. And 5, insured was negligent and is liable for causing MO to contract HPV. The arbitrator found that the amount that would fairly and justly compensate plaintiff MO for all of her damages and injuries is $5.2 million, and entered an award in that amount in favor of plaintiff MO and against the defendant, the insured. So in the end, the arbitrator awarded her $5.2 million in damages, and so the headlines were sort of right that MO did get a judgment for $5.2 million against the guy that screwed her. Pun absolutely intended. But here, it just wasn't against Geico. Yet. Geico asserted that the plaintiff and defendant had conspired to jack up the damages award in the arbitration. MO's counsel says that this wasn't the situation in their case, that the liability and damages were determined on the merits, and the arbitration proceeding was not based on any admissions, and that it was fairly contested. There were arguments and witnesses going both ways. But after this arbitration award, the woman informed the insured that she would file an action in state court to confirm the damages award, which is what you do. When you get an arbitration award, you then basically confirm it in state court. Now, at this point, Geico tried to intervene. They wanted a new trial because they didn't think the arbitration was fair. That motion was denied. But at the same time, in April of 2021, Geico filed a separate suit in federal court in the District of Kansas, seeking a determination that it has no duty to defend or indemnify MB, the guy with HPV. So Geico chose to fight its case on two fronts, one in the state court and one in federal court. And it's really the federal court case that's going to determine on the merits whether Geico actually has to provide a defense or provide indemnity based on the contract language. We'll come back to that in a second. Now, in state court, Geico argued that the judgment in the arbitration violated the company's due process rights, and the arbitration agreement was unenforceable. Geico said it never had an opportunity to participate in discovery or to provide a meaningful defense, and by the time that they were aware of the judgment, they argued it was too late. And you can see some merit to this. They didn't get a chance to contest the facts in this more or less secret arbitration where the claimant and the insured might have colluded to drive up the award. And at the very least, the insured didn't care because by virtue of the agreement that he made, he wasn't on the hook for the damages. So he might not have colluded, but he also didn't care if there was this giant judgment because the plaintiff, MO, was just going to turn around and sue Geico over it. Now, on the other hand, this arbitration and this award, it's not against Geico. It's an award against MB, the HPV guy. If Geico was right that the policy doesn't cover it, then they don't have to pay. And we'll talk about that in a second, whether the policy covers it. And if Geico wanted to participate in this from the very beginning and they were worried that they would have to pay indemnity to MB or cover his defense costs, then they could have provided him a defense from the very beginning. That's the point of the duty to defend. And that's why state laws are often crafted in a way to incentivize insurance companies to provide a defense. Because you can't go back in time and provide a defense after the fact. So if you, the insurance company, are worried that you might have to cover the damages award, well, then provide a defense to the guy that you provided insurance and participate throughout the entire thing. As the Missouri court found, quote, Geico's claim of constitutional deprivations presumes Geico was denied the opportunity to defend its interests relating to MO's claims against insured, including the ability to challenge liability and damages. But Geico did have the opportunity to participate and defend its interests, including the ability to challenge liability and damages by entering a defense of the insured. Geico did not take advantage of this opportunity and instead denied coverage and refused to defend insured. Moreover, Geico initiated a declaratory judgment action in federal court seeking a determination as to its obligations under the insurance policy. And that federal action provides yet another forum in which Geico may defend its interests. And right, the federal court action. Geico is currently suing in federal court for an order that says the policy doesn't cover the HPV transmission at all. And if they win, they won't have to pay anything, no part of the $5.2 million, because that judgment is only against MB. So the headlines were wrong. There has been no determination that Geico is responsible for this $5.2 million award. For now. There's also no determination that Geico wrongfully denied a defense to MB, but they might. Now, usually if someone files an insurance claim because they were injured in a car, it's because of an accident. That's one of the reasons that this seems like an unfair ruling. It puts insurance companies in a weird position of defending any and all claims, no matter how bonkers they might seem. But it's really a question of whether the insurance policy actually applies to this scenario. Geico asserted that there's no way its policy can be interpreted to include this kind of negligence the woman sued over, the contracting an STI in a car. But to determine that, we have to look at the policy language. Generally, since insurance companies write these policies, the language is construed against them. Let me know if you've ever had a chance to write a custom insurance endorsement. Generally, the insurance company gives you what they give you, which is why policies are often hundreds of pages long. They're trying to prevent any and all weird situation. So in this particular case, what does the policy say? Well, I had to do some digging, but I found the relevant language in Geico's appellate brief. According to Geico, the policy covers bodily injuries arising out of the ownership, operation, maintenance, or use of a motor vehicle. Now, you might notice that language is very broad. Does this type of injury arise out of the ownership of a car? Well, it seems like a lot of stuff arises out of the ownership. Does it qualify as use of the motor vehicle? Maybe. Is this a bodily injury? Maybe. Is it the type of bodily injury that's intended to be covered by an insurance policy? Who knows? But for the most part, you're just looking at the text and the meaning of the words that are in the policy itself, construed against the insurance company or in the light that is more favorable to the insured. So it's possible that Geico might have to cover this, because if it's even possible that this language covers this situation, then Geico was wrong to deny defense to MB the insured, and they're going to be on the hook for not only the attorney's fees, but also the award of damages itself. But we'll know soon. Geico filed a lawsuit in federal court seeking a declaratory judgment that it is not responsible for this situation, and that is scheduled for trial in October. But even if Geico loses, don't consider this a license to engage in unsafe sex, because you can bet that Geico has already changed the policy language in all of its car policies to make sure that no future policies cover this situation in the future. But either way, it seems this is the new McDonald's hot coffee case. People completely misunderstood what was happening in this particular case. But it is another example of using your car for weird things. But really, people, instead of using your car, since we're all working from home, you should upgrade your decoration. I recently upgraded my office with the help of today's sponsor, Displate. Displate sells high-quality metal art prints that couldn't be easier to install. I've been using Displate literally for years, even before they were a sponsor. Here, let me show you. Here's the one I've had for years. Easy to switch out. Boom. Adjust it. Looks good. Displate is great because you never have to deal with a cheap looking plastic frame or trying to make sure it's perfectly straight. Because you can hang them up using magnets, installation is a breeze, and you can easily swap them out with whatever you want. There are no nails and no holes. You can adjust it or replace it however you want. Displate has millions of designs ranging from movies, vintage posters, maps, art, music, nature, and the list goes on and on. I actually chose a bunch of inside legal jokes. Here's a patent application for a gavel. But whether you are a law nerd like me, you will find something that you love that you want to display every single day. And this month, Displate is offering a summer sale where if you purchase using the link below, you'll get 25% off 1 or 2 displates and a whopping 29% off 3 or more. And it's automatically applied to your cart at checkout. So click on the link in the description or the link that's on screen right now to automatically get a huge discount on whatever displate that you want and revamp your home or office. Plus, clicking on that link really helps out this channel. And while you're at it, click on this playlist over here with all of my other legal videos. So click on this link or I'll see you in court. Trump's Truth Social is worth billions. Question mark? Sure, you've got the red hat. You've ordered the gold sneakers, maybe you even shelled out $60 for a commemorative edition Trump Bible. But now's your chance to give him unlimited amounts of money directly. What better way to stick it to the libs than make a self-proclaimed billionaire even richer? And despite all that, something about this feels wrong. So to explain this amazing once-in-a-lifetime growth opportunity is chaos lawyer Liz Dye.
Thanks, Devin. The Trump Media and Technology Group just finished its first week as a publicly traded company. In that time, the stock whipsawed around wildly. But on paper, the former president has gotten several $billion richer. And many people are wondering if he'll be able to tap into those assets to pay the bond and stop the New York Attorney General from seizing Trump Tower. The appellate division did Trump a major solid and reduced the amount he'd have to pay from $454 million plus interest to $175 million. But that is still a whole lot of money. The question is, will he be able to sell some of his newly minted stock to get a bond or to pay off his judgments? And the answer is no, probably. Trump Media and Technology Group, or TMTG to its friends, was the brainchild of Andy Litinsky and Wes Moss, two former Apprentice contestants who came up with the idea for a Trump-branded media empire in early 2021 after Trump tried to overthrow the government and got kicked off of social media. According to the Washington Post, Litinsky and Moss spotted a business opportunity and reached out to rappers Lil Wayne and Kodak Black to arrange a meeting. The rappers were both pardoned on Trump's last day in office, and so they had an in Trumpland. And it worked. Just 3 weeks after Trump's allies laid siege to Congress, Litinsky and Moss trooped down to Mar-a-Lago, and over cheeseburgers, Diet Cokes, and ice cream, the men offered to build Trump a media company that he would own 90% of without putting in any of his own money. What a deal! Trump accepted, and they were off to the races, sort of, because Trump had just tried to overthrow the government. And so lenders were understandably skittish about handing him a giant wad of cash, particularly for a project explicitly linked to his personal brand. What Litinsky, Moss, and Trump needed was to merge with a special purpose acquisition company, aka a SPAC, sometimes known as a blank check company. A SPAC is essentially a pot of money looking for something to spend it on. The pot incorporates as a company, collects investor cash, and then takes itself public on one of the major stock exchanges, after which it finds a private company to merge with. Taking a company public is an intrusive process with a lot of intrusive paperwork. But if a SPAC, which is already public, comes along and buys a private business, then the private business can mostly skip opening up its books to Uncle Sam and the Securities and Exchange Commission. And Donald Trump has not fared well when he's had to open up his books to government investigators. So merging with a SPAC, which would allow them to bypass all that unpleasantness, was the way they needed to go. In February of 2021, Litinsky, Moss, and the Trump tech team hooked up with a money guy from Miami named Patrick Orlando. He had just launched a SPAC called Benasseri Capital Acquisition, which had $100 million in investor capital and was looking for a company to buy and take public. But the Benasseri-Trump media merger never happened, and that's where the trouble started. Because the SEC rules say very clearly that a SPAC has to take itself public before negotiating with a target company. But Orlando was so excited to be doing business with Donald Trump in February of 2021 that he documented the occasion in multiple photographs. Orlando and Trump wound up using a different SPAC, Digital World Acquisition Corp, or DWAC, and not Benasseri. And that decision came back to bite them hard. Because during those negotiations, Orlando had not taken DWAC public yet, which is a huge no-no. And despite the fact that Orlando had been talking to Trump's people for months, Digital World told the government multiple times during 2021 that it had not selected any specific business combination target, and we have not, nor has anyone on our behalf, initiated any substantive discussions directly or indirectly with a business combination target. So that would prove to be an expensive mistake. But in the meantime, the brain geniuses behind Trump Media got to work on this amazing pitch deck. Cool graphics, bro. Trump Media's founders described it as a mission-driven organization that would fight for the First Amendment protections and freedoms of all Americans, protect democracy, and defend capitalism. Okay. They promised to create a media powerhouse to rival the liberal media consortium and fight back against the big tech companies of Silicon Valley, who have used their unilateral power to silence opposing voices in America. They vowed to even the playing field, because if big tech can censor the President of the United States, then they can censor everyone. But, like, how, maybe? Well...
Phase 1, collect underpants. Phase 2, Phase 3, profit.
Yeah, more or less. First, they promoted their inclusive big tent approach that would unite liberals and independents and conservatives. At the same time, they pointed to political segmentation in the US media landscape and promised to exploit it by triggering a mass exodus of conservatives from traditional media. But really, the only draw here was Trump himself. But the backers of the project were sure that Trump's tens of millions of followers on Twitter and Facebook and Instagram would happily decamp to a new conservative platform where they could receive his pearls of wisdom. And once those conservators were inside the Trump media ecosystem, they'd want to give all their money to Trump-related businesses. And soon enough, the Trump tech stack would be bigger than Facebook and Netflix and Amazon combined. But seriously though, how were they going to make money? The first pair of magical underpants was Truth Social, a Twitter knockoff site that joined Parler and Gab in trying to replicate Twitter without all those pesky hall monitors kicking you off for saying racial slurs or telling people to drink bleach. And they didn't mean Twitter circa 2024. They meant Twitter pre-Elon Musk, when journalists camped out there all day long, ruining their attention spans and setting the agenda for national media. The beginning was admittedly rocky. As Washington Post reporter Drew Harwell noted, before Truth Social's official launch, you could get on to a beta version of the site and register accounts using names of prominent officials. So on October 20th of 2021, the pinned post on @DonaldJTrump was a photo of a pig defecating on itself. But in February of 2022, the actual site went live, and on Valentine's Day, Trump even used it to publish a little love note. Oh, sweet. For 3 months, that was it for the former president. But by the summer, Trump was back to his regular social media habits. He was waking up early to rant at his enemies and post clips from conservative media, and he was letting people know who was up and who was down in Trumpland. But apparently, Truth Social didn't defend democracy and capitalism hard enough, because the platform failed to attract the promised tens of millions of users. Even Trump, the main character on Truth Social, has only 6.84 million followers today, as compared to the 89 million he had on Twitter alone when he got booted off the site on January 7th, 2021. The internet analytics site SimilarWeb estimates that Truth Social had 5 million visits last month. In comparison, Twitter had 5.8 billion visits, and Facebook had 15.3 billion. And while visitors to those large social media sites spent upwards of 10 minutes per visit, users clicked away from Truth Social after less than 5 minutes. And if you've been on the site, you know why. But that is not what you want when the entire purpose of the exercise is to monetize eyeballs. Meanwhile, Digital World was hoovering up cash from investors eager to own a piece of Donald Trump. So by fall of 2022, Digital World was sitting on upwards of $1.2 billion. But by then, the company was also under SEC investigation.
Oh, sorry to interrupt, Liz, but it looks like they're gonna need some good lawyers. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've been accused of insider trading, fraud, or overthrowing an election, well, you can probably go somewhere else. But if you've suffered from a data breach, especially if you got one of those data breach letters, were involved in a car crash, or dealt with sexual harassment, we can represent you or help find you the right attorney. It's so important to talk to a lawyer right away so you can find out what your options are and get the best representation right from the start. So click on the link below or call the number that's on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. So click on the link below if you want a great lawyer.
In June of 2022, the Southern District of New York, that's SDNY, impaneled a grand jury to investigate Orlando's early coordination with Trump, and SDNY subpoenaed board members of TMTG and DWAC. Then in August, Will Wilkerson, one of the company's first employees, filed a whistleblower complaint with the SEC, handing over reams of documents and emails alleging wrongdoing by DWAC and TMTG's management, which is a whole mouthful of alphabet soup and also not what you want when you're trying to effectuate a corporate merger. Because of the investigation, the merger between Digital World and Trump Media could not go through in 2023. And that delay put Trump and Truth Social in a very weird spot. Because even as Digital World was sitting on a mountain of cash just waiting to plow it into Trump's company, Truth Social was losing money hand over fist. The Wall Street Journal reports that the company had revenues of $3.4 million and a net loss of $49 million in the first 9 months of 2023. Wilkerson also revealed that Trump, who had gotten 90% of the company for agreeing to be associated with it, had pressured Litinsky to give some of his shares to Melania. Meanwhile, Don Jr. and Eric were asking to be cut in as well, and they didn't want their portion to come out of their father's share. In July of 2023, Digital World agreed to settle with the SEC for $18 million, admitting that it made materially false and misleading statements and omissions about negotiating with Trump before the SPAC went public. 3 men in Florida were also charged with insider trading based on their knowledge of the merger talks. And as the merger got closer, the litigation got uglier. On February 15th, the SEC finally approved the deal, after which Litinsky and Moss sued Trump Media in Delaware for trying to dilute the value of their shares, reducing their stake in the company from 8.6% to 1%. Digital World and TMTG sued Patrick Orlando in Florida, claiming that he was threatening to block the merger as a means of extorting more cash from the company. And back in Delaware, Orlando sued TMTG right back, claiming that it was trying to swindle him out of 2 million shares. But on March 22nd, the deal finally went through. Shareholders voted to merge Trump Media with Digital World. At long last, Truth Social was a publicly traded company. The merger was approved on a Friday, with trading on the NASDAQ not set to begin until Tuesday. But at the same time, Donald Trump faced a major legal and financial problem. He needed to put up a $464 million bond in the New York civil fraud case, plus a boatload of interest, and he did not have the cash. The insurance agency Chubb had fronted the $91 million for the bond in the E. Jean Carroll case. But according to the Trump Organization's lawyer Alan Garten, Chubb backed out of negotiations to underwrite the bigger note because it refused to accept real estate as collateral, or at least not on terms that Trump could agree to. On Truth Social, Trump yelled that he had almost $500 million in cash, which undercut his lawyer's claims that he would be irreparably harmed if he had to front the $464 million and sell his properties. But Trump says a lot of crazy things, like blaming the trial judge for the 9% interest rate on appeals bonds and claiming that he would have to post the bond if he wanted to appeal. Absolutely none of that is true. The interest rate in New York is set by state law, and you can appeal anything you want. But if you want to stop the winning party from collecting on a judgment, you have to let the court hold the money in escrow while you try to get the decision overturned. So Trump didn't need to find $464 million to appeal the verdict. He needed it to make sure that New York Attorney General Letitia James didn't put a lien on Trump Tower and auction it off to pay the judgment. Luckily, no one with skin in the game believed a word that Trump said. And you can prove that because Trump Media's stock price fell almost 14% after the merger was approved, and the media started speculating that Trump was about to sell some of his newly minted shares to fend off the Attorney General. In plain English, if a major stockholder starts selling off millions of shares, it will tank the stock price for everybody else. And over the weekend, investors got nervous that Trump was going to do just that so he could pay the bond and avoid having his property seized. When companies go public, they usually have an agreement that imposes a lockout period on early investors to stop them dumping all their shares at once and screwing the little guys who bought later. And the Trump SPAC agreement is no exception. It says that for 6 months, none of the early investors, including Trump, can lend, offer, pledge, hypothecate, encumber, donate, assign, or sell any of their shares. So that means that Trump can't sell his portion, and he can't use it as collateral for a loan or a bond either. And that is where Patrick Orlando's little oopsie with Benassere cost Trump big. Because if these guys hadn't lost a year to SEC investigations, the merger would have happened a long time ago, and Trump would be out of the lockup period by now. In any event, the Trump company's board could always waive the lockup requirement and let Trump dump his stock anyway. Now, don't faint, but the board is full of Trump's cronies, including his former trade representative, Robert Lighthizer, Linda McMahon, the former WWE executive who headed up Trump's Small Business Administration, former National Security Council member Kash Patel, who just so happens to be a witness in at least 2 of Trump's criminal cases, and Devin Nunes, the former California representative who quit Congress to become CEO of Trump's media company. Nunes is a former dairy farmer with a degree in agriculture, so he definitely knows how to run a media company. And of course, there's Don Jr., because what would a Trump company be without nepotism? This board seems likely to do whatever Trump asks, possibly even letting him pull the rug out from under the poor schlubs who bought this stock retail if and when he gets desperate for cash. But on March 25th, the first judicial department in New York threw Trump and his investors a major lifeline. The appellate court reduced Trump's bond to $175 million and gave him another 10 days to post it. Investors breathed a sigh of relief, since cutting the amount he'll have to pony up by 60% means that Trump can probably get the money from Chubb. And that means he won't need to make a desperate raid on his stock to avoid losing his entire real estate empire. And that's certainly what the market thought, because Trump Media, which is now trading under Trump's initials DJT, went up 35% when the appeals court's ruling dropped. But that's a short-term solution to a long-term problem. So unless an appeals court overturns the E. Jean Carroll verdict and the civil fraud order, Trump is eventually going to have to come up with more than $500 million. And even before that, he's got a pretty strong incentive to sell that stock while it's still worth several $billion. Because lots of commentators have called Trump Media, or DJT, a meme stock. Even the wild-eyed liberals at the Wall Street Journal are saying it. That is, DJT is a stock whose price gets bid up by individual investors for reasons having nothing to do with its underlying value. And here, the underlying value isn't a lot. The company was launched with a promise to take on Facebook, Amazon, Apple, Netflix, and Google, aka the FANGs. So far, that hasn't happened. As of now, it's basically a Twitter clone with a relatively paltry number of users that bleeds cash and struggles to find advertisers. But that hasn't stopped the share price from rocketing since it hit the market, thanks to MAGA superfans who want to show support for their leader. These are people who literally believe that DJT is going to wind up buying TikTok, a company with upwards of $16 billion in annual revenue. That's not real. As Axios' Felix Salmon points out, meme stocks don't trade on fundamentals, and DJT could rise a whole lot higher even if the business continues to lose money for a very long time. But unlike GameStop and the other meme stocks, the little guys buying up DJT stock are not doing it to drive up the price and stick it to a bunch of hedge fund villains who shorted a beloved brand because it was worth more dead than alive. The MAGA buyers want to show their support for Trump and make him even richer than he is now. Trump Media's board has functionally acknowledged that the company's valuation doesn't make sense by any recognizable metric. In a recent SEC filing, they wrote, "At this juncture in its development, TMTG believes that adhering to traditional performance indicators such as signups, average revenue per user, ad impressions and pricing, or active user accounts including monthly and daily active users could potentially divert its focus from strategic evaluation with respect to the progress and growth of its business." Because why would a social media site concern itself with silly metrics like ad revenue and number of users? In fact, the board says that it may find it challenging or cost prohibitive to do that kind of bean counting for the foreseeable future, and it may never collect, monitor, report that kind of unimportant data. All of which leads one to wonder, what is the real purpose of this exercise? Because if Trump Media can't be bothered with the boring stuff like building out its customer base or finding advertisers, what exactly are they selling? Maybe the company's initials can provide us a clue. And if Trump isn't about to dump this stock and leave his supporters high and dry, that means he intends to hold on to it if and when he gets back into the White House, which may be worse, because we have seen this show before. When Trump was president, his hotel in D.C. functioned as a conduit for well-wishers to give him cash, and a lot of those well-wishers also wanted things from the federal government. So when Sprint and T-Mobile needed the Trump administration's approval for a merger, they suddenly started booking stays at his hotel and wandering around the lobby in bright pink shirts bearing the company's logo. Lobbyists for the Kingdom of Saudi Arabia reserved hundreds of rooms at the hotel in D.C. within a month of Trump's first election in 2016. Forbes' Zach Everson reports that 31 foreign governments booked stays at Trump's D.C. hotel during his first term of office. And at an event where 100 foreign diplomats convened at the Trump hotel, one actually confessed to the Washington Post that he felt obligated to book his stay there because it would be rude to come to his city and tell the president, "I'm staying at your competitor." And that isn't even counting all the Republican politicians and candidates who filled Trump's pockets by filling his hotel. But with Truth Social, you won't even have to leave your house to shower the president with cash. Foreign countries and Republican candidates and any company with business before the executive branch will simply be able to buy ads on Truth Social and pay the man directly. And if they know what's good for them, they probably will. So if Trump doesn't get elected, he can cash out his winnings and go home. And if he does get elected, he can go to the White House and cash in huge.
Thanks, Liz. And you might know that Trump's payout is looking less and less bigly by the day. After an initial surge to $79 on March 26th, the DJT stock fell sharply when the company revealed in an SEC filing that it booked just $4.1 million in revenue during 2023. As Fast Company notes, that's about what an average McDonald's franchise brings in per year, except actually selling Big Macs is actually profitable. And during 2023, Truth Social had a net operating loss of a whopping $58 million. And with Trump owning an estimated 57% of the company, that is a wild swing in the DJT's share price, and it's already cost him billions of dollars. But not to worry, because the company's board promises to grow its customer base through the, quote, overall appeal of the Truth Social platform. And now, as of the time of this recording, the stock has fallen almost 50% into the low 40s. But what's interesting about the ruling on the DJT stock plummet is it's been covered extensively by over 130 news outlets, with 37% of the reporting coming from the left and only 14% coming from the right. But if you compare the headlines, you'll start to see some really interesting framing. On the left, you have outlets focusing on how this financially benefits Trump despite the drop, while the right news outlets stick to discussing the markets and stock price trends at large. Now, these framing and word changes are subtle, but they play a big role in how readers perceive the story. The first set of words suggests unfairness to Trump's gain and that he's not really a good businessman, while the second set of words suggests the merger was just business as usual. And this is all possible thanks to today's sponsor, Ground News, a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. Ground News gathers related articles from around the world and compares coverage across the political spectrum. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. And the blind spot feed, which highlights stories that are disproportionately covered by one side of the political spectrum. Ground News is a fantastic tool for sifting through daily misinformation and bias, especially in an election season. They provide all the tools you need to be a critical thinker, and I cannot recommend them enough. It's my favorite news aggregator and research tool. And what's great is that right now they're offering 40% off of unlimited access to all Ground News features. All you have to do is click on the link that's on screen or down below. You can only access this discount through my link, so click on the link that's on screen right now and you'll get 40% off of Ground News and support an independent news platform working to make the media landscape more transparent. And after that, click on this link over here for more LegalEagle, or I'll see you in court. Former Congressman Matt Gaetz, ooh, that has a nice ring to it, tried like hell to prevent the congressional report of his misdeeds from coming out, including filing a lawsuit that went nowhere. But now the report of his sexcapades is out for, better or worse. Yes, it's only been about 1 month since Gaetz withdrew his appointment as America's top law enforcement officer, and now the House Ethics Committee just released a disturbingly graphic report of his behavior, which details the accounts of 12 women that Gaetz paid a combined total of over $90,000 in exchange for sex and illegal drugs, including, allegedly, a 17-year-old minor. What happens next? Well, here to break down this insane story of lust, lies, and the law is chaos lawyer Liz Dye.
Thanks, Devin. On November 13, Donald Trump announced his intention to nominate Florida Congressman Matt Gaetz as Attorney General. Gaetz immediately resigned from Congress despite having just run for and won re-election to his seat. The move was seen as a transparent attempt to head off the release of a report by the House Ethics Committee on allegations that Gaetz had participated in sex trafficking, including of a minor. Republican House Speaker Mike Johnson vocally opposed releasing the report to the public, even as its conclusions were pretty clearly relevant to Gaetz's fitness to be the top law enforcement officer in the land. But Gaetz's notoriously obnoxious behavior, including his habit of whipping out his phone to show off nude pictures of his sex partners, was no secret in D.C.
This is a guy that the media didn't give a time of day to after he was accused of sleeping with an underage girl. And there's a reason why no one in the conference came and defended him, because we had all seen the videos he was showing on the House floor that all of us had walked away of the girls that he had slept with. He'd brag about how he would crush ED medicine and chase it with an energy drink so he could go all night. This is obviously before he got married.
For the record, that was then Congressman, now Oklahoma Senator Markwayne Mullin, who said he might still consider voting for Gaetz as Attorney General. But Mullin aside, it became clear almost immediately that the Senate would never vote to confirm Gaetz. So November 21, he withdrew his nomination, and now he's headed to One America News Network to read the news to its dozens of viewers every day.
And bringing on a firebrand of a talk show host to our primetime lineup, may I announce Matt Gaetz and the Matt Gaetz Show coming next month to OAN. Hey, Matt.
Initially, the committee voted against releasing the report, with all Republicans opposed. But at a closed-door meeting on December 5th, 2 Republican members switched their vote and agreed to make it public on the 23rd. The report is now out, and it's icky. Gates defended himself by saying that my 30s were an era of working very hard and playing hard too. It's embarrassing, though not criminal, that I probably partied, womanized, drank, and smoked more than I should have earlier in life. Which sounds conveniently like he was just a kid blowing off steam in an age-appropriate boys will be boys way. They said Representative Gates took advantage of the economic vulnerability of young women to lure them into sexual activity for which they received an average of a few $100s after each encounter. In fact, the committee found that the 42-year-old congressman paid very young women for sex and drugs, including one girl who was 17 at the time. That is statutory rape as a matter of Florida law. They also noted that he voted against the Frederick Douglass Trafficking Victims Prevention and Protection Reauthorization Act of 2022 and was the lone no vote in 2017 on legislation to establish an advisory committee that would coordinate efforts to prevent human trafficking, a vote he defended by pointing to his work in the Florida legislature to broaden the definition of duress in the state's trafficking laws to include economic duress. The committee also found that he violated multiple House rules about disclosure of gifts and services to women who were not his constituents. Many people have insisted that Gates should have been prosecuted by the Justice Department. Friend of the channel Mitchell Epner suggests that the real failure was that of local Florida prosecutors. To understand what really happened here, we'll have to first talk about a bunch of grifters and weirdos, several of whom wound up in jail. It's a wild story that involves public Venmo transactions, a kidnapped Iranian hostage, and the love hotel emoji, which is apparently a thing on all our phones. Who knew? Okay, SPF up, because it's time to meet some spectacular Florida men. First up, Joel Greenberg, the former tax collector for Seminole County. Under Florida law, tax collectors are elected officials responsible for collecting taxes, obviously, but also for issuing various permits and government documents, including driver's licenses. Greenberg is currently in jail for committing a truly wild array of crimes. He once caused a fire in a county building where he'd commandeered the county's servers to mine bitcoins. He doled out $3.5 million in state government contracts to various friends and acquaintances, including the groomsmen at his wedding. And he sent letters to the school where his political opponent worked, impersonating students and falsely accusing his rival of being a pedophile. But what brought him into the ambit of federal investigators and eventually ensnared Gates was Greenberg's habit of generating fake state IDs for himself and for the women he was sleeping with. On Monday, April 16, 2018, an employee at the Lake Mary branch of the tax collector's office opened up shop and discovered that the alarm wasn't on. She also found a bunch of expired driver's licenses, which were supposed to be shredded, strewn all over Greenberg's desk. She reviewed the security camera footage where she saw that Greenberg had been in the office with an unidentified man. And when the employee texted, Greenberg responded that he'd been showing Congressman Gates what our operation looked like. You know, on the weekend, in the middle of the night, as one does. When Greenberg got picked up by the feds in 2020 for stalking his political opponent online, he had at least 5 fake IDs on him, which is why the cops went and talked to the people at the Lake Mary office, and that's how they got to Gates. Because as soon as the FBI started pulling at the threads of Greenberg's nasty personal life, they found that he was inextricably tied in with Gates's own sordid stuff. Greenberg recruited very young women off the sugar daddy website Seeking Arrangement, paying them to spend time with Greenberg, Gates, and their male friends. The arrangement included sex and often drugs. And one of those girls turned out to be a 17-year-old high school junior, which meant that she could not legally consent to sex with an adult over the age of 24 under Florida law. In June of 2020, Greenberg was charged with stalking and identity theft. And in August of 2020, the Justice Department filed a superseding indictment against him for child sex trafficking, which meant that the feds had a very sleazy person in custody with a very strong incentive to say absolutely anything that might save his skin. In early 2021, the New York Times reported that Gates was under federal investigation for sex trafficking in relation to the 17-year-old girl. Gates insists that this was a politically motivated act by Joe Biden's henchmen. But the reality is that the investigation began during the waning days of the last Trump administration when Bill Barr was still the Attorney General. And while the investigation was still going on behind closed doors, reporters were hot on the trail, Although, to be fair, they didn't have to dig very deep since Gates and Greenberg both left their Venmo history public until well into 2021. The Daily Beast reported that in May of 2018, Gates Venmoed Greenberg $900, writing in the memo line, "hit up" with the name of the 17-year-old girl. The next morning, Greenberg Venmoed the girl and two other women in 3 separate transactions denominated as school, and tuition, totaling $900. Gates denied paying women for sex, telling the Daily Beast, "The last time I had a sexual relationship with a 17-year-old, I was 17. But before it dawned on him that he would be wise to make his Venmo private, reporters Jose Pagliari and Roger Sullenberger clocked thousands of dollars Gates sent to Greenberg, including one transaction for $300 on November 1, 2018, with the love hotel emoji in the memo line. The Daily Beast confirmed that Greenberg did indeed book a hotel for that evening in Winter Park, Florida. And that turned out to be just the tip of the iceberg. According to the House report, using personal checks, Venmo, and Cash App, Gates sent more than $90,000 to 12 women in exchange for sex and drugs. Gates denied ever paying for sex, telling Axios in March of 2020, "I have definitely, in my single days, provided for women I've dated. I've paid for flights, for hotel rooms. I've been, generous as a partner. I think someone is trying to make that look criminal when it's not." Here he is on Tucker Carlson trying to remind the former Fox host of the fun dinner Matt and one of his generous partner dates shared with him and his wife.
I can say that actually you and I went to dinner about 2 years ago. Your wife was there, and I brought a friend of mine. You'll remember her. And she was actually threatened by the FBI, told that if she wouldn't cop to the fact that somehow I was involved in some pay-for-play scheme, that she could face trouble.
Awkward.
Now, obviously, if you're going to engage in illegal prostitution and record everything on Venmo, you're going to want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've gotten in a car crash, suffered a data breach, especially got one of those data breach letters saying that your information might have been leaked, or are dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. It's so important to talk to a lawyer right away so you can maximize your recovery. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. So click below.
Gates claimed that he and his father had been victims of an organized criminal extortion involving a former DOJ official seeking $25 million while threatening to smear my name. He said that his father had been cooperating with federal authorities in this matter and wearing a wire at the FBI's direction to catch these criminals. And that part turned out to be more or less true. See, Matt Gaetz has a little touch of the Nepo baby about him, if you can even believe it. In fact, his daddy, Don Gaetz, was a highly successful businessman who served as president of the Florida State Senate between 2012 and 2014. On March 16, 2021, with rumors swirling that Gaetz would be indicted, his father got a text from a former Air Force intelligence officer named Bob Kent saying that his son Matt was about to be federally indicted, but he, Kent, had a plan to make his future legal and political problems go away. Now, stick with me here, because this one's really crazy. Kent and his backer, Florida businessman Stephen Alford, were obsessed with a former FBI agent named Robert Levinson, who went missing in Iran in 2007. Levinson was reportedly on a CIA mission, but he was in poor health, and in 2020, the government told his family that they should presume he was dead, which they did, filing a wrongful death suit against the Iranian government and securing a $1.4 billion award to be paid out of Iranian assets frozen in U.S. coffers since 1980. But for reasons not entirely clear, Alfred and Kent thought that Levinson was alive, or they said they did anyway. So they texted Don Gaetz, "If you and your son are willing to help us privately and clandestinely obtain the release of Robert Levinson, I will ensure that Matt is on the plane that delivers Levinson to his family, thus making him the most sought-after public figure in the world for his efforts to obtain Levinson's release. Then my partner will see to it that Matt receives a presidential pardon, thus alleviating all his legal issues." I think the theory here was that if Gaetz was somehow the guy who brought Levinson home, Biden would have to pardon him because you're allowed to commit sex crimes if you're a national hero. All they wanted from Don Gaetz was a $25 million loan to be repaid out of the federal reward. Alfred and Kent dubbed the plan Project Homecoming and laid out the details in a memo which they delivered to Don Gaetz. But of course, Papa Gaetz wasn't an idiot. He immediately called the FBI to report that he was being extorted and was presumably wearing that wire the whole time, as his son had said. Alford was indicted in 2021 and pled guilty to one count of wire fraud. He's currently a guest of the United States government and will be for a couple more years at least. None of which has anything to do with whether or not Matt Gaetz committed crimes, but it doesn't make it easier to indict him. What it did was allow him to throw glitter in the air and claim that he was being targeted by the DOJ.
What is happening is an extortion of me and my family involving a former Department of Justice official. Tonight, I am demanding that the Department of Justice and the FBI release the audio recordings that were made under their supervision and at their direction, which will prove my innocence.
On April 9th, 2021, the House Ethics Committee announced that it was investigating public allegations that Representative Matt Gaetz may have engaged in sexual misconduct and/or illicit drug use, shared inappropriate images or videos on the House floor, misused state identification records, converted campaign funds to personal use, and/or accepted a bribe, improper gratuity, or impermissible gift in violation of House rules, laws, or other standards of conduct. That investigation got sidelined for 2 years after the Justice Department asked the Ethics Committee to back off and let the criminal investigation take precedence. And look, it's not crazy. If you're a prosecutor, you don't want your witnesses destroying their credibility by saying one thing in congressional testimony and another to you. But that delayed the congressional investigation until 2023 when the Republicans took back the House. Now, Gaetz was known as a blowhard and a bomb thrower among Republicans. But he was Trump's guy, and he figured that meant Republicans would go to bat for him, including then House Speaker Kevin McCarthy. McCarthy was incredibly vulnerable because Republicans had won by the slimmest of margins in 2022. It took 15 rounds of votes to confirm him as Speaker, and that only happened after he granted huge concessions to some of the most aggressive members of his own caucus, including Gaetz. Essentially, McCarthy gave them the ability to call a snap vote on his leadership at any time. Gaetz seemed to think that McCarthy owed it to him to put a stop to the ethics investigation, or at least Gaetz figured that McCarthy's precarious position gave him leverage to make the demand. But McCarthy refused to play ball.
Matt is upset about an ethics complaint. I don't care what they threaten against me. I am not going to interject into an independent committee like ethics.
Meanwhile, behind the scenes, Gaetz was stonewalling the committee. After McCarthy made those comments, Gaetz wrote a letter in September accusing the committee of doing McCarthy's bidding after he publicly signaled to you to put the heat on and instructed you to shoot your shot. In October, Gaetz led a successful effort to push McCarthy out of the job, after which Gaetz switched to claiming that the Ethics Committee's Republicans were on a mission to avenge McCarthy. It was an attempt to inject politics into the process by accusing the committee of playing politics. In reality, the committee was doing its job, and the stuff that it uncovered while it was doing its job was awful. Okay, top line, the committee found substantial evidence that Representative Gaetz had sex with victim A in July 2017 when she was 17 years old and he was 35. Representative Gaetz's actions were in violation of Florida's statutory rape law. So there you go. That's who Trump wanted to put in charge of the Justice Department. But aside from that, it's clear that Gaetz and Greenberg paid at least 12 young women for sex and drugs. One of those women included his girlfriend of 2 years, whom Gaetz met through seeking arrangement when she was 21 and he was 35. Their relationship was not exclusive, and she seems to have corralled other young women to send Gaetz drugs and to entertain him and his friends. She's woman one on this table, receiving almost $64,000. Other women interviewed by the committee testified that woman one would often provide drugs at parties, and woman one, whose lawyers were paid by Gaetz, repeatedly took the fifth when she was interviewed by the committee. Gaetz himself also relied on the girls to bring him drugs. And okay, maybe you're of the opinion that sex work should be legal and drug laws are stupid. Fair. The problem is that these very young women were plied with drugs and alcohol in situations where it's not clear that they were really able to consent to having sex with multiple men and women in an evening. The committee wrote, while all the women that the committee interviewed stated their sexual activity with Representative Gaetz was consensual, at least one woman felt that the use of drugs at the parties and events they attended may have impaired their ability to really know what was going on or fully consent. Indeed, nearly every woman that the committee spoke with could not remember the details of at least one or more of the events they attended with Representative Gaetz and attributed that to drug or alcohol consumption. The girl who was 17 at the time of her encounters with Gates testified to the committee that when I look back on certain moments, I feel violated. I thought all these people were my friends. I know now that they're not. And as exploitative as that was, Gates and Greenberg didn't always pay up as promised. Here's Gates' girlfriend, woman one, explaining that the guys are a little limited in their cash flow this weekend, so Matt was like, if it can be more of a customer appreciation week. So if you had on your bingo card, guy most likely to demand a freebie from a teenage sex worker, hey, congrats. Other texts show him ducking the compensation for one woman because he didn't think she'd stayed long enough, which kind of undercuts the claim from most of these women that this wasn't prostitution or, as Gates put it, sending funds to women he dated. And in fact, the committee said plainly that Gates enticed and procured women to engage in sexual activity for hire and purchased the services of women engaging in sexual activity for hire in violation of Florida state law. Note, that's a state law and not a federal law. The committee investigated whether Gates participated in sex trafficking, particularly with regard to a trip to the Bahamas in 2018. Gates and two other men spent 3 days partying with 6 women, the youngest of whom was 18. Gates is reported to have taken ecstasy and had sex with at least 4 of the women on that trip. At other times, he paid for women to come from Florida to D.C. or New York, including in January of 2019 when Gates appeared as a guest host on the Fox News show Outnumbered. After he went on air to call Senator Elizabeth Warren Sacagawea, the group went to a Broadway show. A lawyer for one of the women told ABC that the show was Pretty Woman, which is honestly a little too on the nose. Ultimately, the committee concluded that they did not find sufficient evidence to conclude that Representative Gates violated the federal sex trafficking statute, although Representative Gates did cause the transportation of women across state lines for purposes of commercial sex. The committee did not find evidence that any of those women were under 18 at the time of travel, nor did the committee find sufficient evidence to conclude that the commercial sex acts were induced by fraud, force, or coercion. They did, however, find that Gates violated House rules on accepting gifts. He failed to disclose that he flew back from the Bahamas on a private plane, a gift valued in excess of the $250 limit under the House gift rule. Gates tried to hide this by indignantly pointing to his travel itinerary, which showed him flying out of Washington Dulles Airport on a commercial flight. When the committee pointed out that he'd forgotten to say how he got home, he got very snotty. He said, "My travel to the Bahamas was a result of my purchase of American Airlines tickets with my personal funds, and it goes without saying that I was not reimbursed by anybody. Does the committee also have an interest in every dollar I spent in the Bahamas on food, refreshments, and other travel provisions such as sunscreen?" That was one of the reasons the committee found that Gates obstructed the investigation, violating his duty of candor as a member of Congress. They also found that he violated congressional rules with respect to constituent services, using official resources to help a woman he was having sex with expedite her passport renewal. In fact, she wasn't his constituent at all. It was incredibly damning, and the committee members also had some very harsh words for the Justice Department. Remember how the Ethics Committee delayed its own investigation by 2 years to avoid interfering with the DOJ's criminal inquiry? That inquiry was closed without charge, which Gates pointed to as evidence of his complete exoneration. That's not what that means, but let's come back to that one in a minute. The committee said that many of the women it interviewed also gave statements to DOJ and urged the committee to rely on those statements in lieu of requiring them to relive their experience. They were particularly concerned with providing additional testimony about a sitting congressman in light of DOJ's lack of action on their prior testimony. The report complained that DOJ refused to provide the relevant statements and other significant evidence to the committee. DOJ cited internal policies about protecting uncharged suspects like Representative Gates, general concerns about how DOJ's cooperation with the committee may deter other victims in other matters, and various inapposite policies relating to congressional oversight of DOJ itself. But that's mostly part of a, for lack of a better term, ongoing pissing match between Congress and the executive branch. Because Congress always wants to get its hands on investigative materials in high-profile cases, and the DOJ never wants to give it to them. In some cases, that's because it can't. It's illegal to disclose grand jury materials without permission of the court, but it would be terrible public policy for Congress to be able to seize and publish internal police investigations of people who were never charged. Who would ever talk to the FBI if that were a possible outcome? And there's just no way to make an exception to this rule that only covers villains like Matt Gaetz. So yeah, you can sympathize with the women here who would have preferred not to be interviewed again by Congress, but you kind of have to put that criticism in context. But let's come back to Gates' claim of exoneration, because a lot of people have said that the Justice Department screwed up by not indicting him. And that includes the committee, which accused the DOJ of not doing right by the 17-year-old girl who cooperated with the DOJ's investigation for years and was let down by the justice system when reports circulated that the DOJ would be unlikely to pursue charges against Representative Gates. First of all, we have no idea why Gates wasn't charged. Again, we haven't seen the internal investigative materials, but we can make some educated guesses. For one thing, the Fed's key witness is Joel Greenberg, who did all the cooperating he possibly could have done, delaying his sentence multiple times, and he still got 11 years. When Judge Gregory Presnell sentenced him, he said he'd never seen a defendant who has committed so many different types of crime within a relatively short period like those crimes committed by Mr. Greenberg. To say that Greenberg has credibility problems is a massive understatement. And the committee itself said that it would not rely exclusively on information provided by Mr. Greenberg in making any findings. Second, the Mann Act, which prohibits transporting individuals across state and national lines for the purposes of prostitution, is a problematic statute for a whole host of reasons. Let's start with the fact that it was originally known as the White Slave Traffic Act of 1910, and one of the first successful prosecutions was of heavyweight champion boxer Jack Johnson, who was black and faced repeated arrests under the Mann Act for traveling in the company of white women. It's historically been used to criminalize sexual relationships that society finds unacceptable by characterizing them as prostitution and/or sex trafficking. And although the law has been amended, it's still so broad that the Justice Department charges under the Mann Act only where there is evidence of a victim of severe forms of trafficking in persons. And whatever you think of Gates, this is clearly not that. Third, the ethics report itself didn't find that Gates violated any federal laws. The youngest woman who traveled with him to the Bahamas was 18, so there was no trafficking of a minor. And if you can't charge under the Mann Act, then the only thing left was violation of Florida state laws. I mean, okay, sure, maybe the feds could have indicted him for the Molly or for having the women mail him marijuana cartridges, but come on. As the ethics committee concluded, Gates violated House rules, which are not prosecutable, and he violated Florida's statutory rape and prostitution laws. So maybe the real question here isn't why didn't Attorney General Merrick Garland indict Gates, it's why didn't Florida prosecutors do it, since they had access to the same media reports suggesting that he paid a 17-year-old girl for sex that Congress and the DOJ did. There was nothing stopping states' attorneys in Florida from stepping up to the plate here, and they don't even appear to have investigated. So while you're looking at people to be mad at, maybe direct your age a little further south. Matt Gaetz had at least a week's notice that this thing was going to drop on Monday the 23rd, but he still waited until that morning to file a motion in federal court in D.C. demanding that the committee not release the report. The case was always doomed to fail. The courts really do not get to tell Congress how to conduct its business. It's kind of fundamental to the Constitution. But the way it went down was exceptionally silly. The case was immediately flagged for being procedurally defective in 3 different ways. At about 10:30 a.m., the report went live on the Ethics Committee website, at which point Judge Amit Mehta demanded that Gates explain why this matter should not be dismissed with prejudice for lack of subject matter jurisdiction, insofar as the case appears to be moot in light of the House Ethics Committee's public disclosure of the report, whose release plaintiff seeks to enjoin. Gates was forced to admit that his complaint was indeed moot, and Judge Mehta dismissed the case before close of business. Gates spent that Monday tweeting through it and has since reposted messages from hundreds of supportive fans. He's also floating a plan to take the oath of office on January 3rd, offer a resolution to expose all congressional sexual harassment settlements, and then resign to start his new gig at OAN. And since his political action committee is still fundraising, it seems entirely plausible that he'll go through with his plan to run for Florida governor in 2026. And okay, yes, Florida does have the opportunity to do the craziest thing possible here, but maybe just this once, don't.
Now, if you're going to tweet through your crimes and run for governor, you'll probably want a good lawyer. Oh wait, I did that already. But given the nature of Gates' alleged crimes, this video was probably demonetized, just like our video on the United Healthcare murder, because we talk about legal issues and subjects that might not be safe for advertisers. But we think they are important to talk about and explain, which is why my friends and I created today's sponsor, Nebula. On Nebula, you can watch all of our videos ad-free and early. because our videos always go up on Nebula first. Plus, there's tons of exclusive content, and we don't have to deal with bogus content ID claims or demonetization. And for a limited time, you can get a lifetime membership. You can buy once and then never again. It's the greatest deal of all. Now, I know tens of thousands of you signed up for Nebula using the CuriosityStream bundle, but unfortunately that's over because they broke it. So if you'd like to support this channel, the only way to ensure that the money you spend on Nebula goes to us is to sign up directly. And if you're new here, Nebula includes tons of exclusive videos from me, original series from your favorite people, movies, plays, classes, and more. I've heard it described as Netflix for people who like trains, with your favorites like Johnny Harris, Neo, Jetlag, Real Engineering, Real Life Lore, and your most favorite LegalEagle. And exclusives on Nebula are getting really good. For example, I can't wait for my friend Patrick Willems' film called The Dinner Plan, starring Griffin Newman, John Hodgman, Miriam Shore, and Zach Cherry, among other famous stars. You can also see my feature-length documentary, Bad Law Words Good, and other Nebula exclusive content, including my full-length interview with the screenwriter of My Cousin Vinny, and my Not Safe for Work video about lawsuits that are too hot for YouTube. Because what's truly special about Nebula is it's a creator-owned platform built by me and other YouTubers and podcasters, and because it's a subscription service, we get to work on larger, higher-budget productions than we ever could anywhere else. It's becoming the answer to the question, how do you get Hollywood-level production value without Hollywood-level BS? And for those of you that want to share everything Nebula has to offer with your friends and family, Nebula is now offering annual gift cards. So if you sign up using my link that's on screen right now, you can give a year of Nebula to a friend for 40% off the yearly subscription. A year of the best content for just $36. And that's a gift that you can give to yourself, by the way, because you deserve it. So get 40% off of you or a friend's yearly subscription at just $36 a year. That's $3 a month for all of your favorite content, or you can check out the lifetime deal where for $300, you can get access to Nebula forever. We're investing in more big concept, high-octane Nebula originals, and your lifetime subscription goes towards that investment. In a way, lifetime is the best possible deal of all. And either way, you'll get all my videos early and get access to the exclusives, support the ambitious projects that my friends and I are working on, all in our own streaming site. So sign up now and get you or a friend 40% off of Nebula at $36 a year, or get the incredible lifetime deal by clicking on the link below. And after that, click on this link over here for more LegalEagle, or I'll see you in court. A comedian tells a joke about the president. Days later, his show is gone from the airwaves, not because of ratings, not because of advertisers, but because the government hinted that bad things might happen if broadcasters didn't fall in line. This is not some overseas puppet regime. This is right here in America with ABC, Donald Trump, and Jimmy Kimmel. Now, when the FCC chair says effectively, we can do this the easy way or the hard way, and the network suddenly pull a late night show, is that smart business or is it government censorship by proxy? Here's how we got here. On September 10th, 2025, right-wing provocateur Charlie Kirk was shot and killed while speaking at an outdoor event at Utah Valley University. Later that day, Jimmy Kimmel posted his thoughts on the tragedy to Blue Sky, saying, quote, "Instead of the angry finger-pointing, can we just for one day agree that it is horrible and monstrous to shoot another human? On behalf of my family, we send love to the Kirks and all the children, parents, and innocents who fall victim to senseless gun violence." Donald Trump praised Kirk as, quote, "great" and, quote, "legendary," and ordered flags to fly at half-staff and offered military honors to Kirk. 5 days later, on September 15th, Kimmel was reacting to the right-wing reaction to Kirk's death, focusing on how Trump and his allies perceived Robinson, the alleged killer of Charlie Kirk.
We hit some new lows over the weekend with the MAGA gang desperately trying to characterize this kid who murdered Charlie Kirk as anything other than one of them and doing everything they can to score political points from.
Now, not that it really matters, but Kimmel did not say anything about Charlie Kirk as a person, but he criticized Trump for exploiting his death. And it wasn't just Kimmel. Tucker Carlson also criticized Trump for exploiting Kirk's murder for political gain. However, Kimmel was already a target for the Trump administration. After a strikingly similar incident involving CBS, in which President Trump seemingly got Stephen Colbert fired, Trump tweeted about Kimmel being fired 2 months ago, quote, "Jimmy Kimmel is next." But it was podcaster Benny Johnson who really got the ball rolling by tweeting, quote, "Jimmy Kimmel went on air and told the ABC audience that Charlie Kirk's assassin was a MAGA conservative, effectively blaming Charlie Kirk for his own assassination." Now, you just saw the clip in question, and I would say that this characterization of Kimmel's characterization is false, but other right-wing media outlets picked up on the thread. And Brian Kilmeade defended ABC.
The point is that Kimmel's comments went way too far for some television executives, not for me, not for you, but for them. And they turned up the heat on Kimmel, the host, to calm down the rhetoric.
Though it does seem the standards for political rhetoric are different for Kilmeade's employer, Fox News, because a few hours before Kirk was murdered, Lawrence Jones told Kilmeade that people who have mental illness and refuse to accept help from publicly funded resources should, quote,
"You decide that you're going to be locked up in jail."
Kilmeade then said, quote,
"Or involuntary lethal injection or something, just kill him."
Now, a few days later, Kilmeade apologized, but he was not pulled off the air or suspended by his employer, and the FCC did not comment. Johnson claimed that Kimmel's comments were a clear-cut violation of the FCC's policy on news distortion, punishable by the revocation of the offending broadcast license. Now, that's complete nonsense. But on Wednesday, September 17th, Federal Communications Commission Chairman Brendan Carr ripped Kimmel and threatened to take FCC action.
It appears to be some of the sickest conduct possible. I think that it's really sort of past time that a lot of these licensed broadcasters themselves push back on Comcast and Disney and say, listen, we are going to preempt, we are not going to run Kimmel anymore until you straighten this out, because we licensed broadcaster, are running the possibility of fines or license revocations from the FCC if we continue to run content that ends up being a pattern of news distortions. I think, you could certainly see a path forward for suspension over this. But frankly, when you see stuff like this, I mean, look, we can do this the easy way or the hard way. These companies can find ways to change conduct, to take action, frankly, on Kimmel, or, there's going to be additional work for the FCC ahead.
Now, Carr made these comments on the Benny Johnson podcast, and I'm sure Legal Eaglets will remember Johnson, the guy who was duped into taking money from Russian state media. But within hours, Nexstar Media Group, which owns many ABC affiliate stations, announced that it would stop airing Jimmy Kimmel Live, quote, for the foreseeable future, over Kimmel's remarks. They said, quote, Nexstar strongly objects to the recent comments made by Mr. Kimmel concerning the killing of Charlie Kirk and will replace the show with other programming in its ABC-affiliated markets. A Nexstar executive said it would stop airing new episodes of Kimmel's show on its ABC affiliates, quote, in an effort to let cooler heads prevail as we move toward the resumption of respectful, constructive dialogue. Sinclair, the largest ABC affiliate in the country, went nuclear, suspending Kimmel's show on its ABC affiliates, demanding an apology and ordering him to give cash to Kirk's family and to his nonprofit Turning Point USA. Jason Smith, the vice chairman of Sinclair, said, quote, Mr. Kimmel's remarks were inappropriate and deeply insensitive at a critical moment for our country. We believe broadcasters have a responsibility to educate and elevate respectful, constructive dialogue in our communities. We appreciate FCC Chairman Carr's remarks today, and this incident highlights the critical need for the FCC to take immediate regulatory action to address control held over local broadcasts by the big national networks. And Sinclair also announced its stations would air a 1-hour tribute to Kirk on Friday night. Now, you might have heard of Sinclair. It's a conservative company that has historically tried to exert editorial control over its affiliate stations. For example, in 2004, it preempted a 2004 episode of Nightline, during which Ted Koppel read the names of every American service member who died in Iraq. Sinclair also made headlines in 2017 by hiring Trump aide Boris Epshteyn to host pro-Trump segments, which it required its local affiliates to carry. That meant that every network it owned, from Seattle to Cincinnati, would throw to Boris for a little pro-Trump pep talk. But in a world where the FCC is punishing people for wrong speak, maybe it's a good idea to protect some of your personal information. Because if your sensitive data falls into the wrong hands, it can lead to fraud and even identity theft. And it's not surprising because data brokers vacuum up all your personal data from all corners of the internet and sell it to anyone who wants to buy it. But you can fight back and take control of your personal data by signing up for today's sponsor, Incogni. Because Incogni removes your personal data from online data brokers by searching the internet and reaching out directly on your behalf, forcing them to take your personal info down. If these data brokers resist, Incogni will take care of that too, because Incogni fights back. And in fact, these data brokers are the reason why in the US you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. It's shocking just how easy it is to find all this information. It also might be why you're getting so many spam calls lately or even had your identity stolen. Now, I've been using Incogni for years, and in that time you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years. Now, I could never do this myself, so thank you to Incogni for saving me weeks worth of work and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the broker removes your data once, they can always collect it and publish it again. So if online privacy is important to you, give Incogni a try. If you click on the link that's on screen or down below, you can try Incogni risk-free for 30 days with a 60% off discount and get a full refund if you're not into it. But if you do decide to keep it, you'll still get the exclusive 60% off discount so long as you use my link or the code LegalEagle, all one word, at checkout. So sign up for Incogni or I'll see you in court. But before we get to the legality or illegality of the steps taken against ABC and Kimmel, there's one more important piece of factual background, and that is the consolidation of American media. American media companies are large and trying to get larger. Disney, for instance, owns ABC, ESPN, Marvel, Pixar, Lucasfilm, Hulu, and more, while CBS, through Paramount Global, controls CBS News, Showtime, Paramount Pictures, and Paramount Plus. NBC, under Comcast's NBC Universal, includes NBC News, MSNBC, Universal Pictures, Peacock, stock and a portfolio of cable channels. But many of these companies are seeking to acquire yet more media companies and need government approval for their mergers and acquisitions, which has led to networks bending over backwards to appease the Trump administration. Disney ABC has a deal in the works for ESPN to buy the NFL Network and NFL Red Zone. In exchange, the NFL will own a 10% stake in ESPN. And this is a massive deal which requires FCC approval. Disney CEO Bob Iger has been urging ABC talent to limit their criticism of Trump. In May, he reportedly told View host Ana Navarro to tone down her anti-Trump rhetoric. And the president of ABC News met with the 5 View co-hosts and asked them to focus more on celebrities and less on politics, but the host would not agree. Now here, Nexstar needs FCC approval to complete a merger with fellow TV company Tegna. That merger can't go through unless the FCC loosens long-standing ownership regulations, including federal laws barring a single entity from owning TV stations that together reach over 39% of American households, and guidelines on the total number of stations that can be owned in a single market. Sinclair is also purchasing new local networks and selling others, and guess what? It has to get FCC approval for those moves. Now, Carr didn't mention Sinclair or Nexstar when he criticized the Kimmel show, but the networks responded quickly, probably because Carr has made it clear that he will put his thumb on the scale for Trump allies. And in fact, earlier this year, he pressured Comcast to renew its deal with the regional affiliate, the Yes Network, on favorable terms. Comcast had been pushing its regional sports networks to more expensive tiers on its Xfinity platform, and in some cases dropping them altogether. But Yes Network, home of the Yankees, complained to Carr, and he warned Comcast that the FCC would step in. Quote, "The FCC does have authority to step in and address claims of discriminatory conduct." And Comcast made a temporary deal to keep the Yes Network through the baseball season. Which brings us to an important question. Who is Brendan Carr and why does he have all this power? But I want to make clear, the FCC mainly only regulates broadcasters because the idea is that broadcast spectrum is a limited resource. But even there, the agency has limited legal authority to act on complaints relating to the content of television or radio programming. In fact, it's basically non-existent. From the FCC's own website, quote, "The FCC's authority to take action on complaints about the accuracy or bias of news network stations, reporters, or commentators in how they cover or sometimes opt to not cover events is narrow. The agency is prohibited by law from engaging in censorship or infringing on First Amendment rights of the press. Those protected rights include, but are not limited to, a broadcaster's selection and presentation of news or commentary." Or at least that's how things used to work before the Trump administration. And Congress, through Section 326 of the Communications Act, explicitly declared that nothing in the statute, quote, "shall be understood or construed to give the Commission the power of censorship over broadcast communications or signals transmitted by any broadcast station, and no regulation or condition shall be promulgated or fixed by the Commission which shall interfere with the right of free speech by means of over-the-air broadcast communication." As the FCC's official site points out, quote, "Pursuant to these legal mandates, the FCC has long held that the public interest is best served by permitting free expression of views." Well, Brendan Carr is a lawyer who served on the FCC between 2017 and 2024. In 2025, Trump promoted him to chairman. Now, in 2022, at the White House Correspondents' Dinner, President Joe Biden defended the concept of political satire even when it was aimed at him, and comedians then roasted Biden during the dinner. And afterward, Carr heartily agreed that comics should practice political satire. Quote, "Biden is right. Political satire is one of the oldest and most important forms of free speech. It challenges those in power while using humor to draw more people into the discussion. That's why people in influence positions have targeted it for censorship." But now Carr has praised Disney ABC for, quote, "doing the right thing." He encouraged other broadcasters to, quote, "follow Nexstar's lead," and he said that affiliates should, quote, "push back on Disney programming that they determine falls short of community values." But perhaps most ominous, Carr wrote the chapter in Project 2025 about weaponizing the FCC. In it, he framed the FCC chair as having unique authority and laid out how that role would shift under a Republican administration. He suggested that the chair should aggressively use their regulatory leverage to force broadcasters to change. He suggested revisiting media ownership rules and the FCC's public interest standard, and he advocated for stripping platforms of their immunity from liability under Section 230, which, of course, cannot be done without legislation. But Carr also took aim at public broadcasters, NPR and PBS, suggesting that they shouldn't keep their federal funding or their licenses. And as you might have read in the news, the Trump administration has acted on those plans. Now, there is only one Democrat left on the FCC, Ana Gomez, and she criticized the Trump administration, saying that, quote, "an inexcusable act of political violence by one disturbed individual must never be exploited as justification for broader censorship and control. This administration is increasingly using the weight of government's power to suppress lawful expression." And Trump personally voiced approval of the FCC's tactics, posting, quote, "Great news for America. The ratings challenge Jimmy Kimmel's show is canceled. Congratulations to ABC for finally having the courage to do what had to be done. Kimmel had zero talent and worse ratings than even Colbert, if that's possible. That leaves Jimmy and Seth, two total losers on fake news NBC. Their ratings are also horrible. Do it, NBC, President DJT." And Trump faith outreach coordinator Jenny Korn praised companies that fire their employees.
They've shown their evil. And thank goodness for companies now who are firing nurses and teachers and people like Jimmy Kimmel, because people should not be able to celebrate others' deaths in a very public way and then keep their job.
Now, Kimmel did not celebrate Kirk's death, but that didn't stop the threats, actual and implied, from the government. So the question is, can they do that? Now, first, it's worth noting that even if Kimmel had celebrated Kirk's death, the Supreme Court has upheld the right to celebrate people's deaths, as awful and hurtful as that may be to the person's family and friends. In Steiner versus Phelps, the court said that the First Amendment shielded the Westboro Baptist Church from tort liability for picketing and protesting military funerals, including calling dead soldiers anti-gay slurs and saying things like, "Thank God for dead soldiers" and "You're going to hell." Now, this is the rule even if those things are said in front of the dead person's family, and it causes them deep pain, as it did for the family of Lance Corporal Matthew Snyder, who was killed in Iraq. And additionally, the First Amendment doesn't stop your boss from firing you. That's because the First Amendment is a restriction on government power, not on private employers. In order for a plaintiff to have standing to sue, they have to demonstrate that the government was responsible for the violation rather than a private actor. This is known as state action. If you work at Starbucks and you call your manager a fascist, you don't get to sue Starbucks for violating your free speech rights when they fire you. And your boomer manager might lack a sense of humor, but he doesn't work for the government, so it's not a First Amendment violation. And generally, ABC, as a private network, can suspend Kimmel or fire him or force him out for almost any reason, depending on what his contract says, even if that reason seems dumb, ill-advised, or it feels like a lie. And we saw an example of that when CBS canceled Stephen Colbert earlier this year. At the time, CBS's parent company was trying to get government approval to sell Paramount to Skydance Media, but Trump had sued 60 Minutes. And the network eventually paid Trump $16 million to settle the lawsuit, and the FCC approved the sale of Paramount for $8 billion. And executives then announced that they would not renew Colbert's contract when it expired. That is a somewhat similar situation, but obviously the links here are more tenuous. Many people thought CBS forced Colbert out due to government pressure or the implied pressure of the whole situation, and maybe an overabundance of caution by the executives at CBS to get the deal to go through. But at the time, there weren't really explicit government threats, and Colbert's still on the air until June of 2026. And CBS's actions might have been craven, but they probably were not unconstitutional, though. Maybe at some point I will have to do a governmental bribery analysis of that whole situation. But private companies can take adverse actions against people for their speech, provided they act on their own. However, the government doesn't get to launder its own censorship through private companies. If the government pressures or coerces a private actor into punishing someone's speech, then it becomes state action and the Constitution applies. The principle recognizes that the government can abuse its power to get private actors to do its dirty work. And state officials don't always need to take an enforcement action to shut someone up. Sometimes they just suggest that a company might want to take action and hint that bad things will happen if they don't, kind of like a mob boss. And that's still unconstitutional. This is sometimes known as jawboning. Think of it like this. If the FBI agents illegally search your house, that's a Fourth Amendment violation. If the FBI convinces your nosy neighbor to break in and give them your computer, that's also a Fourth Amendment violation. And the principle is that the government can't do indirectly what it is forbidden to do directly. And in the First Amendment context, the Supreme Court first elaborated on this doctrine in Bantam Books versus Sullivan. In 1962, Rhode Island had created a commission to encourage morality in youth, which sounds so benign that you know it's just horribly illegal. What they actually did was send letters to book distributors listing objectionable titles and warning that the police would be notified if the books stayed on shelves. The objectionable materials included the novel Peyton Place and magazines like Playboy. Now, the commission had no formal power to censor books, but everyone knew the cops were backing them up. So distributors quickly pulled the books to avoid trouble. The Supreme Court held that it is unconstitutional for the government to intimidate private parties into suppressing speech. And the Supreme Court reaffirmed those principles recently in 2024 in a case called NRA versus Vullo. In that case, Maria Vullo, then superintendent of the New York Department of Financial Services, sent letters to banks and insurance companies informing them that doing business with the NRA might attract heightened regulatory scrutiny by DFS. Her letter said the company should, quote, continue evaluating and managing their risks, including reputational risks that might arise from their dealings with the NRA or similar gun promotion organizations, review any relationships they have with the NRA or similar gun promotion organizations, and 3, take prompt actions to manage these risks and promote public health and safety. And the NRA interpreted this as a threat to private businesses. In essence, that New York was the mob boss saying, cut ties with the NRA or else we'll make your life miserable. And after a meeting with Vullo, some companies like Lloyd's agreed to stop underwriting NRA-related policies. And the NRA sued, alleging that Vullo coerced DFS-regulated parties to punish or suppress the NRA's speech. And in a unanimous opinion written by Justice Sotomayor, the Supreme Court held that Vullo had violated the First Amendment. The court emphasized that, quote, a government official cannot coerce a private party to punish or suppress disfavored speech on her behalf. And the Vullo court fleshed out the Bantam Books framework by creating a multi-factor test. When assessing whether there was a government coercion, a court has to consider the official's regulatory or enforcement authority, the content, tone, and purpose of those communications, and whether the communication could reasonably be understood as a threat or inducement. The more direct authority a government official has, the more likely a private actor will feel they must comply. Vullo had the power to initiate investigations, assess fines, and make criminal referrals. And in analyzing her tone, the court considered whether the communications seemed to be trying to persuade those businesses to do something, or whether the message was really a threat. And Vullo's letters were bad because she said she would focus her enforcement on certain entities, and she implied that DFS would ignore other infractions if a private party cut ties with the NRA. So we can look at the Kimmel situation using the Vullo framework. The Supreme Court said that courts should look at the controversial government communications in context rather than as isolated statements, and draw inferences that favor the plaintiff. So if we were planning a lawsuit on Kimmel's behalf, we'd look first at the scope of Carr's authority as chairman of the FCC. The FCC chair wields regulatory authority over broadcast licenses and merger approvals. The FCC also has some authority over what airs on broadcast television, but it's limited to regulating obscenity, which is an exception to the First Amendment, and these days is generally limited to sexually explicit material. And theoretically, the FCC also has some limited ability to regulate profanity. Those rules apply even in late night hours, though the courts have recognized broadcasters get more leeway after 10 p.m. But either way, being mean to Trump or Charlie Kirk's estate is not indecent or obscene or profane. It's core First Amendment speech. But it's pretty obvious by now that broadcasters believe that Trump's FCC will penalize them if they don't do what the president wants. That's probably why ABC and CBS have both settled bogus lawsuits. As Liz Dye recently explained in her video about Trump's newest lawsuit against the New York Times, there is only one Democrat on the FCC, so this isn't a situation where companies can shrug off comments by the FCC chairman, and that makes Carr's statements more coercive. His threats carry real regulatory weight, just like Vullo's. And Carr's public and private statements explicitly referenced regulatory consequences. He said, quote, "There might be a path forward for suspension and additional work for the FCC ahead." He wasn't asking for civility or persuasion, he was threatening to take action. And in an interview with Sean Hannity, Carr doubled down, accusing the news networks of conspiring against Trump to rig the 2024 election. He then said, quote, "Trump punched back, and when he did so, he was standing up for the American people that simply don't trust those outlets anymore. We at the FCC are going to enforce the public interest obligation. There's broadcasters out there that don't like it. They can turn their license into the FCC." And not to mention the mob-like statement of "we can do it the easy way or we can do it the hard way." It's hard to imagine getting more clear than that. Carr shares Trump's conspiracy theory about election rigging, believes the media hates Trump, and believes the FCC can clamp down on broadcasters who don't comply. Carr said the media ran a narrow partisan circus during 2024, and that, quote, "whatever the public interest means, it's not that." And yes, the FCC grants licenses to broadcasters to operate on behalf of the public. That doesn't mean that the affiliates must carry programming that praises Trump or that they can control the content of those broadcasts. And of course, the president weighed in, taking credit for the move and promising to pull other licenses.
When you have a network and you have evening shows and all they do is hit Trump, that's all they do. But when you go back and you take a look, all they do is hit Trump. They're licensed. They're not allowed to do that.
So did Carr's comments influence Nexstar and Sinclair? It definitely looks like it, and Carr issued a statement, and hours later, Disney, Nexstar, and Sinclair pulled Jimmy Kimmel Live from their affiliates and demanded apologies and donations. And Rolling Stone reports the quote, "In the hours leading up to the decision to pull Jimmy Kimmel, two sources familiar with the matter say senior executives at ABC, its owner Disney, and affiliates convened emergency meetings to figure out how to minimize the damage. Multiple execs felt that Kimmel had not actually said anything over the line," the two sources say, but the threat of Trump administration retaliation loomed. Now, this all bolsters Kimmel's argument that this was government coercion. And this is relevant because the plaintiff has to show that the challenged communications could plausibly be understood to convey a threat of adverse government action in order to punish or suppress speech. And it seems the broadcasters perceived a serious threat. And I want to be clear here that they absolutely did not need to cave. Just as ABC didn't need to settle the Stephanopoulos defamation lawsuit, and CBS didn't need to settle Trump's lawsuit accusing the network of manipulating an election by interviewing his opponent. But this doesn't necessarily let them off the hook. But I do think their behavior is based on what the Trump administration is telling them, that Trump will use the power of the government to punish them for their speech and their right to assemble. And I'm sure that Carr will claim that he was doing his job, which is reminding broadcasters that the FCC has standards to enforce. But the Supreme Court has said that an official can't insulate themselves from liability by citing legitimate investigatory powers. Vullo also had authority to regulate, but that doesn't mean that she had a free pass to weaponize it against speech that she didn't like. And the network and the broadcasters were well aware that the FCC decides whether their licenses get renewed, whether their mergers get approved, and whether they stay on the air. But that highlights one of the difficulties of this case, which is the action taken against Kimmel was indirect. ABC, Disney, and the broadcasters chose to take these actions before the government had actually chosen to take adverse action. Unlike the NRA, ABC doesn't want to fight this. And one might draw analogies to another case that was decided along the same times as Vullo, called Murthy versus Missouri, where the plaintiffs alleged that social media platforms restricted their COVID-19 content because the government, through officials like Surgeon General Murthy, coerced the plaintiffs to suppress certain speech. But in the Murthy case, the Biden administration basically just pointed out COVID misinformation to the various platforms. It's not clear that there was any coercion to take the information down, but the case was bounced largely on standing reasons. The Supreme Court ruled that the plaintiffs failed to show that the platforms acted because of coercion, rather than as an independent actors exercising their own judgment. In particular, the court pointed out that many platforms had started limiting or moderating COVID-19 content before communications from government officials began, which undercut the claim that government pressure was the decisive cause of the moderation. So here someone might argue because ABC and Disney already had business or editorial reasons to sideline Kimmel, that could weaken the argument that the government's jawboning or threats were the motivating factor in firing Kimmel. But it also goes to show the incredible danger of when the government just makes punishing speech part of its general strategy. At one point, they don't need to make threats anymore because everyone just knows that they will be punished if they do or say things that the government doesn't like. And we don't know exactly what happened behind the scenes, but Rolling Stone reports, quote, "They were pissing themselves all day." And another source said, quote, "They were terrified about what the government would do and did not even think Jimmy had the right to just explain what he said." And what complicates all this is that there are many decision makers and not all of them have the same interests. People at the very top of the pyramid like Bob Iger are highly motivated to get their business deals approved by the FCC. ABC News might be more worried about his ability to independently report on the administration. And the Kimmel Show brings in a lot of advertiser money and the entertainment division would hate to lose that. But since it's clear ABC doesn't actually want to fight this, that basically only leaves Jimmy Kimmel. And I'm not entirely sure that he has standing to do so. He can plausibly argue that his suspension was a direct result of unconstitutional government coercion, but then again, he might not have standing to file a claim. To have standing, a plaintiff must show a specific injury that is actual or imminent, not hypothetical. And that injury must be fairly traceable to the defendant's conduct, and it must be likely redressable by a court. And in a case alleging government coercion, the plaintiff needs to show that a specific decision was caused by government pressure, and that a court ruling could even remedy that injury. Even if a plaintiff shows that the government pressure was decisive, they also have to show that a court ruling could undo or remedy the harm. In Vullo, the NRA had standing because they were injured by the state's actions. In this case, it's different because ABC, Sinclair, and Nexstar were arguably injured by Carr's coercion, so they would have standing to sue, but they clearly don't want to. And in First Amendment context, courts sometimes grant standing to parties alleging speech suppression, and that's complicated when the plaintiff is not ABC itself, but potentially a third party like the host of a TV show. But there's also a remedy issue. Even if Jimmy Kimmel has standing, he probably can't get an injunction because the injunction would be against ABC to force them to carry his show, and that would be compelled speech against ABC, which is one of the reasons it's so murky if ABC just refuses to fight. And viewers almost never have standing to sue when a program is taken off the air. The Communications Act doesn't provide a private right of action allowing viewers to sue over news, bias, or standards or decency because of misinformation. Maybe Disney ABC shareholders, but a shareholder derivative suit is really difficult under these circumstances. Owning Disney stock doesn't usually give shareholders the right to sue over day-to-day programming decisions. However, they can file a shareholder derivative lawsuit for harm done to the corporation by its directors and officers, but standing for shareholders is based on injury to the corporation, not the individual, and generally requires a breach of fiduciary duty by the directors against the corporation, and that's buoyed against the business judgment rule, which presumes that business judgments by the company are legitimate. So we live in very dangerous times where the government is, I think, clearly suppressing speech. But it might not matter because there might not be anyone willing to fight, or the people that might fight can't. Very dangerous times. So for those of you that want to stand up, I salute you. And if you need a good lawyer, I know a guy. Now, after I started this channel, every week I'd get hundreds of comments and emails from viewers who are dealing with legal problems. And they'd ask, can you help me find a lawyer? Or how do I know if this attorney is any good? And there's a massive gap in our justice system. It's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up doing nothing or hiring the first attorney who calls them back. And that really bothered me. So I started to wonder, what if there was a different way? What if we could build a law firm that actually lived up to the values that I talk about on this channel? Transparency, accessibility, and putting clients first. instead of chasing billable hours. A firm where you don't need to pay anything up front, and your lawyers only get paid if you do to maximize your opportunity for justice. So a few years ago, I decided to fix that problem. I decided to start my own personal injury law firm. And honestly, it wasn't an easy choice. But I realized I was in this unique position. I had this platform, this community, and the experience. Not to get rich, trust me, there are easier ways to make money than starting a law practice. But we did it because access to justice shouldn't be a luxury. Because finding the right legal representation shouldn't feel like playing Russian roulette with your future. And when you work with my firm, you're not just getting a lawyer. You're getting a team that understands that behind every case is a real person with real stakes. If we can't represent you, or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, located right where you are, not just whoever happens to be available. So if you're dealing with a personal injury, a car crash, a data breach, sexual harassment, a social security or workers' comp issue, give us a call at the number on screen or click on the link below. Now, I can't represent everyone that watches this channel. I wish I could, but what I can do is make sure that when you need legal help, you have somewhere to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we partnered with, you'll get the same principles of honesty and education that we bring to every video. And if you're dealing with a legal issue and you're not sure where to start, check out the link in the description. Let's have a conversation about how we can help you find not just a lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about, making sure that when life gets complicated, you don't have to face it alone. Which is why when you need a lawyer, you don't just need a legal team, you need the Eagle team.